is where the committee stage should be at. I would much rather that this had occurred in select committee, but we're not at that situation, sir, and I commend the amendments.
Dr. Kennedy-Grant.
Thank you, Mr. Chairman. I don't want to take up too much of the committee's time in view of the need for speed, but let me begin first by just paying tribute to the ministers, starting, I think, with the Honourable Rick Barker and right through, obviously, to the Honourable Simon Power and ministers in between for the indefatigable work that has been undertaken in this bill. It's a 10-year project, more or less, and huge amount of effort has gone in, both by officials, to whom I also acknowledge, and ministers. And it is not a simple task. And we understand the thrust of the bill. We understand the well-intentioned purpose of the bill. And we would prefer not to stand in the way, and we know that we won't be. Mr. Chairman, let me also say right off that the Green Party is quite pleased to be able to support the amendments, the SOPs submitted by the Minister, and as well by Charles Chauvel as, in our view, improvements upon the improvements. I also want to recognise the quite extraordinary efforts that the Minister has put in the last couple of weeks to get agreement. On that basis, I can only proceed from now with just a touch of sorrow that we don't appear to have got complete unanimity in the House, in the sense of at least netting us all, although hope can spring eternal for 5 or 10 minutes, in the sense that we, for our part, wish to put forward, we have whittled down our concerns, or at least our concerns have been met, to the point of only 3 remaining. And it might not be beyond the realm of the imagination, at least, if not the possible, that we could to arrive at the consensus on those 3 as well, which would no doubt trigger support from the Green Party. But I'm going to identify the 3, and in the best constructive spirit, we will be putting forward, or have done on the table, 2 SOPs and a late amendment to address those 3 issues. Each of them are in the context of the broad theoretical comments I was making in my second reading speech, where it seems to me that the essence here is a trade-off between judicial efficiency and the principles of fairness. And we're going to come down on different sides on that, and that perhaps reflects a different political philosophy as to which constituent segments of society we're representing. I did say that, in my view, we could strive to be as efficient in our judicial system as possible, but not at the expense of fairness, when we must not breach the perimeter of that fairness for the sake of any marginal incremental efficiency. And I recognise that there can be different judgments made on that. Where we appear to differ at the moment is on 3 areas. Let me fast forward to clause 128, where the clause, as I understand it, as proposed now, would have the court proceed in the absence of a defendant, unless the court is satisfied, providing the court is satisfied that the defendant will not be prejudiced. And yet you could have a defendant having a reasonable excuse, which the judge recognises as a reasonable excuse, and yet the judge proceeds in the absence of the defendant. We think that unduly penalises the defendant, and in SOP 284, we would propose adding the 4 words at the end of 28.3, the words, and the defendant consents. In our view, that returns the balance of fairness, as we identified, back to the status quo ante. So I recommend that particular amendment to the Minister and to the House. The second one is clause 431. We have it in SOP 285. And it is here that we just part company on the overall thrust. The Sentencing Act identifies somewhere around 15 areas of aggravating factors which a judge can take into account in determining a sentence, and can increase a sentence if any of those aggravating factors are present, but they are all pertaining to the substance of the crime. Particular cruelty, abuse of position of authority or trust, and so on. They all pertain to the crime. None of them pertain to the procedure of the trial. Now we would have the bill, Mr. Chair.
Dr. Kennedy Grant.
Now we would have the bill allowing a judge to increase a sentence, increase incarceration purely through procedural non-compliance in the course of a trial. We believe that procedural non-compliance is in a category of its own, should not be included in an aggravating sentence of a factor of that kind. So we simply propose that Clause 431 be omitted, and in our view, that would also be within the context of that balance between fairness and efficiency. And now to the big one for us, and it pertains to the jury trial issue, which has been there right throughout from the very beginning. And we recognise the complexity of this matter. I have been through pretty thoroughly the comments from the Attorney General on it in his Bora review. I've looked at the Law Society, the Law Commission, the District Court judges, and those against the idea, the Community Law Centres, the Human Rights Commission, and others, and the Criminal Bar Association. And I see opinion coming down on either side. If you increase it from 3 months to 3 years, those were the basis on which the submissions were submitted. I understand that the argument is to increase it to a certain level for the sake of efficiency and financial cost cutting. We understand the reason. In our view, the reason is not sufficient to alter the Bill of Rights Act. We understand the Bill of Rights Act is not entrenched. It should be. It isn't. We understand that a right to a jury trial is not a universal human right. We understand there are different systems. We understand that in the common law system, it is arbitrary, at least it is for societal determination, where the threshold of a jury trial is. We recognise that it can be 5 years in Canada, 10 years elsewhere. We recognise that there is probably agreement, I think, as Charles Chauvel said. It is not a science. It's an art. Let's get the art correct. We also have noted comments that the Minister might wish to comment on this, but our understanding from some of the submissions is that it is by no means proven that there would be massive and guaranteed cost savings by raising the threshold. That gives us pause as well. We speak, Mr. Chair, for those people out there in New Zealand society who may choose to engage in civil disobedience, who may choose to go to the edge of the law, and at times consciously violate the law in a peaceful manner for what they take to be a higher purpose. We are going to stand firm for those people. We do not think cost cutting and the efficiency of the judicial machinery should be at the prejudice of those people who are well-intentioned. Let them have a fair trial at 3 months. Let them be able to elect a jury. There are cases, there are argumentation that if you raise it beyond the 3 months, you are prejudicing the inherent right to a fair trial of certain people. The Minister might wish to dispute that. That's a position we take. And we take it in full responsibility for them, in full recognition of the thrust of the bill. It is sufficiently important for us to oppose this bill on that point alone with great sorrow, because we know the amount of work that's gone into it. We know the complexity. We know the well-intentioned effort. We will not compromise on that point, and I hope that that is respected. I do appeal at this last minute to the Minister and the Government and the House to understand where we are coming from on this point, and at this late stage to drop that reference to 2 years instead of 3, 2, we understand that point too, and keep it at 3 months, and that would make the difference. So we have submitted an amendment at the end. It's late, it's on the table. And it would simply, I don't need to go into detail, we've been here long enough to know how it works. It would simply restore the situation to the current law of 3 months for an election of jury trial. And I appeal to the Minister and others to accept that, and then indeed we probably have unanimity. Thank you.
Stuart Nash.
Yeah, thank you very much, Mr. Speaker. There are